Is standing doctrine an appropriate tool for calibrating the power of regulatory agencies? As you ponder this question, consider this additional background information relating to Massachusetts v. EPA that is not part of the excerpt in our casebook. As you ponder this question, consider this additional background information relating to Massachusetts v. EPA that is not part of the excerpt in our casebook. First, some very general background on the administrative state and administrative law. The Constitution mentions only three branches of government: the legislative, executive, and judicial. So where do administrative agencies such as the EPA fit in? Usually such agencies are organized under the executive branch. Congress lacks the expertise to issue detailed rules in many technical areas such as environmental protection. Further, as circumstances and technology change, such rules must frequently be amended. There's a need for a kind of speed and flexibility the legislative process cannot supply. Congress therefore creates a basic legislative framework and delegates authority to an administrative agency to conduct detailed rulemaking under that framework. Again, we'll discuss this further in Units 3, 4, and 5, but for now, note that the modern court generally has upheld Congress's ability to make such delegations to administrative agencies housed in the executive branch. One of the big issues raised by the growth of the administrative state is the question of democratic accountability. There's theoretically at least a broad form of democratic accountability over executive branch agencies in that they are accountable to the president, who is accountable to the voters. But that very broad sort of accountability does not really address what say, if any, the public has in specific rules an agency might adopt. To address this concern, in 1946, Congress passed the Administrative Procedure Act, the APA, which provides procedures for public notice and comment relating to proposed agency regulations. The APA also requires federal agencies to give interested persons a right to petition for issuance, amendment, or repeal of a rule. And some environmental statutes include specific provisions for this kind of petition. The United Nations International Panel on Climate Change, IPCC, issued its first comprehensive report about the link between human greenhouse gas emissions and climate change in 1990. In 1999, a group of 19 private organizations, including environmental advocacy organizations and alternative power companies, filed such a rulemaking petition with the EPA to regulate greenhouse gas emissions from new motor vehicles under the Clean Air Act. In 2001, during the notice and comment period for this proposed regulation, President George W. Bush requested a report on global warming from the National Research Council. The NRC endorsed the findings of the IPCC, although it noted that a causal link could not be unequivocally established. In 2003, however, the EPA, under then-Director Christine Todd Whitman, the former Republican governor of New Jersey, appointed as EPA chief by George W. Bush, denied the rulemaking petition. The grounds for denial were that, 1, the relevant statute, the Clean Air Act, did not authorize EPA to issue mandatory regulations to address global climate change, and 2, even if EPA had such authority, it would be unwise to exercise it because the causal link between human activity and climate change could not be unequivocally established. After the rulemaking petition was denied, the private organizations, joined by a number of state and local governments as interveners, sought review of the rulemaking in federal court. A panel of the D.C. Circuit Court of Appeals, in a 2-1 opinion, denied the petition for review, and the Supreme Court took certiorari. The excerpt in our casebook only addresses the issue of standing. The majority also held that the EPA should address the rulemaking petition on the merits or supply specific statutory reasons why the proposed rules were inappropriate. This issue also broke 5-4 along ideological lines. Eventually, the EPA did issue a number of rules relating to greenhouse gases, the Clean Cars, Clean Trucks, Clean Power, and Methane Pollution Standards, all adopted during the Obama administration. These are among the regulations President Trump's EPA Administrator Scott Pruitt questioned before his resignation on July 6, 2018. What does this additional background about the Massachusetts v. EPA case suggest about how questions of standing in public interest litigation play into broader policy debates about big issues such as climate change and environmental protection? Can a judicial finding about standing or lack of standing in such cases serve as a proxy for more fundamental policy choices? What does the issue of standing in such cases say about institutional competence and power to decide the underlying policy questions? The Clapper case summarized in the notes has been important in my specialty of cybersecurity law. That case was brought by public interest organizations who claimed some of their members were adversely impacted by the bulk metadata collection program instituted after the 9/11 attacks and disclosed in the documents released by Edward Snowden. This also was a 5-4 decision, with Justice Kennedy this time joining the conservatives. The note in our text summarizes how Justice Alito, writing for the majority, and Justice Breyer, in dissent, applied the doctrinal standing test to these facts. What other concerns might have motivated the split decision? Do you see any patterns emerging regarding judicial philosophy, political ideology, and standing doctrine? I also want to point out the summaries in the notes of Raines v. Byrd and Hollingsworth v. Perry. These cases address interesting questions about legislative standing and standing issues arising from direct democracy measures. Raines v. Byrd holds that individual legislators or groups of legislators who voted against a piece of legislation that ultimately was enacted into law cannot challenge the resulting law's constitutionality absent some other particularized injury. In such a situation, the losing legislature's remedy is to seek repeal or modification of the law through the legislative process. In Hollingsworth v. Perry, California voters had approved a ballot initiative that overturned a state Supreme Court decision allowing gay marriage in the state. The ballot initiative was challenged by 2 same-sex couples, and California's governor and attorney general refused to defend against this challenge. Voters who were proponents of the ballot initiative were allowed to intervene. The Supreme Court held that these voters lacked standing to intervene. Hollingsworth highlights some interesting problems that arise from state ballot initiatives, which bypass traditional concepts of representative government.